Hello, judges. My name is Kyle Townsley, and I am the Assistant Director of Judicial Relations for the LSU Law Center's Board of Advocates. Thank you all for volunteering your time to judge this fall's Robert Lee Tullis competition. Your time judging is greatly appreciated by the competitors, the Board of Advocates, and LSU Law. This year's case is one regarding wrongful employment retaliation and wrongful infringement on reputation liberty interests. The case this year is University of New Plymouth versus Sanderson. In this case, Dr. Winifred Sanderson, a former assistant professor of medicine at a public university, claims she was fired in retaliation for a blog entry she posted on her non-university hosted website. Prior to her firing, Dr. Sanderson had espoused fringe beliefs about chemtrails, such as the link between diet soda and autism, the dangers of mercury in orange juice, and chiropractic treatment for epilepsy. While she never taught any of these beliefs in her University of New Plymouth courses, she posted a blog entry on her personal self-funded webpage suggesting that chiropractic treatment could be used as a cure for epilepsy. Dr. Sanderson purchased the domain name herself and completely self-funded the operation of the website. The website contained her blog, which was largely personal in nature with some references to medical topics. Dr. Sanderson used her winifred.sanderson@npu.edu email address to post on the blog. The email was shown on the bottom of each post. Dr. Sanderson did not otherwise identify herself as being affiliated with the University of New Plymouth anywhere on her website, except in her biography page, where she mentioned her employment along with the rest of her background. On January 14, 2016, Dr. Sanderson posted a blog entry suggesting that chiropractic treatment could be used as a cure for epilepsy. Dr. Sanderson urged practitioners to forego traditional treatments for their epileptic patients. She claimed that most doctors rely far too heavily on pharmaceuticals and overlook useful therapies by using such a myopic focus. Commentators on the blog argued both sides of the merits of Dr. Sanderson's recommendations. The discussion was not limited to her theories on epilepsy treatment, but also on the issue of over-reliance on pharmaceuticals. The blog entry went viral, had 50,000 views within a matter of days, and the local news website linked to the blog entry. After reading the blog entry, Dr. Emily Binks followed Dr. Sanderson's recommendations and advised her client William Butcherson to stop taking his anticonvulsive medications and instead engage in chiropractic treatment. Dr. Binks advised Mr. Butcherson that he would experience approximately 3 days of seizures, would fall into a deep sleep, and would wake up completely healed. Once Mr. Butcherson began this alternative treatment, he began to experience frequent seizures, became unable to walk, and was severely dehydrated, and later fell unconscious. He lay on the floor in a diaper, catatonic, for 2 days. Dr. Binks warned Mr. Butcherson's family not to take him to the hospital because Mr. Butcherson needed to purge the drugs in order to heal. When Mr. Butcherson stopped breathing, his family rushed him to the emergency room, where he was pronounced dead as a result of the uncontrolled epilepsy combined with dehydration. There is no evidence that Dr. Sanderson ever spoke with Dr. Binks or was contemporaneously aware of her actions. During the televised wrongful death trial that followed, Dr. Sanderson and the University of New Plymouth received negative publicity. In a letter dated April 6, 2016, a group of 10 prominent physicians and alumni of the University of New Plymouth called for Dr. Sanderson's dismissal. Dr. Sanderson was sent an email asking her to meet with Dean Dennison, but she didn't respond. Dr. Sanderson subsequently was fired on April 24, 2016. Her former employer, the University of New Plymouth, issued a press release that Dr. Sanderson claims damaged her reputation and made it impossible for her to subsequently find employment. The press release stated that the university had parted ways with Dr. Sanderson due to her dissemination of advice inconsistent with the standards of the University of New Plymouth. The University of New Plymouth asserts that Dr. Sanderson's speech was not subject to First Amendment protection, and that she was not deprived of liberty interest in her reputation. Dr. Sanderson hired an attorney and filed a complaint in the United States District Court for the District of New Plymouth against the University of New Plymouth on June 5, 2016. In this complaint, Dr. Sanderson raised two claims. First, her liberty interest in her reputation had been infringed in violation of her due process rights, and she was retaliated against in violation of her right to freedom of speech. The University of New Plymouth filed a motion for summary judgment in the district court, which was granted. Dr. Sanderson appealed. The 14th Circuit Court of Appeals reversed the district court's grant of summary judgment, and the University of North Plymouth applied for a writ of certiorari, which was granted. The issues presented on review are: by issuing the press release, did the University of New Plymouth infringe on Dr. Sanderson's liberty interest in her reputation under the 14th Amendment? And by firing Dr. Sanderson for statements made in her blog, did the University of New Plymouth violate Dr. Sanderson's free speech rights under the First Amendment? For further discussion regarding these legal issues, please see your bench brief. In your bench brief, you will find a discussion of applicable law and arguments likely to be made by competitors. Your job as a justice on the United States Supreme Court is to assign scores based on the performance of the student attorneys, and to ask students' attorneys probing questions as if you are a judge on the appellate panel. Please direct your attention to the bench brief for a list of sample questions that you may be interested in asking. You will rate the individual presentations and ability to respond to questioning of each student according to the scales listed in the general scoring rubric. Please review the general scoring rubric, which assigns categories of excellent, good, average, fair, and weak before scoring competitors. You are evaluating the competitors solely on their appellate advocacy skills, technique, and style, not on who would win the case if this were a real trial. At the conclusion of the trial, please ask the competitors to step outside of the courtroom while you total the scores. Give the score sheet to the timekeeper and have competitors go back into the room for your critique, which should be about 15 minutes for all competitors. The critiques are important for constructive and informative learning. Please let competitors know what they did well and what could use improvement. Also, please do not tell competitors who won the appellate argument. For many students, this is their first time to be in a courtroom-light setting, so your careful listening and commentary is very important to these competitors. In your package you will find a copy of the bench brief, the competition rules, and the score sheet. Please review the score sheet before you allow the appellate argument to begin, and double check that the first page is filled out properly. Thank you again for volunteering as a judge for the Tullis competition. The Board of Advocates truly appreciates your commitment to the education of young students at LSU Law.